Hello everyone, today we'll deal with what is a compromise of a suit or when a compromise decree in a suit can be passed. So basically compromise means the mutual settlement of dispute between the parties. Sometimes the parties to a dispute feel that why to go to the court, it will be unnecessary and also unnecessary expenses and also much struggle. So they decide to settle the dispute between themselves by mutually or by compromise or an agreement. So the general principle is that all matters which can be decided in a suit also can be settled by means of a compromise. And Order 23 rules 3 to 3b of the Civil Procedure Code deals with the compromise of a suit or a compromise decree. So now let's start the by referring to the relevant provisions. So Order 23 Rule 3 says there are two things: satisfaction of the court and satisfaction of the plaintiff by the defendant. So the first one, court's satisfaction. When the court is satisfied that the suit has been adjusted wholly or in part by an lawful agreement, and it must be writing or signed by the parties and in the second case, where the defendant satisfies the plaintiff that in respect of whole or any part of the subject matter of the suit. First one is court satisfaction, second one is plaintiff satisfaction by the defendant. Then in these two cases, the court shall record such agreement or the compromise or any satisfaction and shall pass a decree accordingly, which is called compromise decree. Let's learn through an example. Suppose there has been a money suit filed for recovery of rupees 3 lakhs. There are parties, plaintiff and defendant. They went into an agreement or an compromise was made between themselves, and that was in writing and signed. And what was that agreement about? That the defendant will pay those 3 lakhs in a specified time. So they will be avoiding the unnecessary litigation. So this example falls under the first part of Order 23 Rule 3, that is of court satisfaction. And if defendant does not fulfill its promise or the agreement, then the plaintiff can enforce it by levying execution of such. Secondly, suppose the defendant satisfies the plaintiff. For the second example, defendant satisfies the plaintiff that I have already given you rupees 3 lakhs, and the plaintiff also agrees with the defendant, and plaintiff also agrees that I will not enforce any suit or case against you. So this is the second part example where the defendant satisfies the plaintiff. First one is the court is satisfied, second one is the plaintiff is satisfied. So now let's see the conditions before passing a compromise decree. So there must be an agreement or a compromise. It must be in writing and signed by the parties. The agreement must be lawful and it must be recorded by the court. Then only the court can pass a compromise or a consent decree under this rule. So the explanation to this rule says that any agreement made between the parties, if it is void or voidable as per the Indian Contract Act 1872, then it shall not be deemed as lawful. It is unlawful. So it must be valid and not void or voidable as per the Indian Contract Act. So another point, who may record the compromise or the agreement or the satisfaction? It may be recorded by the court where the proceedings are pending. Secondly, in case of a suit, by the trial court, and in case of appeal or revision, by the appellate court or the revisional court. These courts may only record. Now let's see Rule 3A of Order 23. It says bar to suit. No suit can be filed to set aside a compromise decree on the ground that it is not lawful. So it was the leading case is Trilokinath Singh versus Anirudh Singh. Secondly, Rule 3B, it says about representative suit. It says no agreement or compromise in a representative suit can be entered without the leave of the court. So it can be entered with the leave of the court, and when the court grants leave, then notice shall be given by the court to all other parties of the representative suit. Now let's see the appeal section of compromise decree, whether appeal can lie against a compromise decree. So section 96 clause 3 of the CPC says no appeal lies against a decree passed by a court with the consent of the parties. So now let's see, there are two types of compromise decree. That means compromise decree can be obtained by two types: compromise decree on contest, compromise decree on consent. So 96.3 says that consent is non-appealable, but the compromise decree obtained on contest is appealable. Now let's see an example. Compromise decree on consent. Suppose A is the plaintiff. There is a suit pending against X, Y, Z, who all are defendants. A and X, Y, Z, all the defendants agree, entered into an agreement. They filed a petition and a joint memorandum of the compromise. Then the court will record the terms and conditions of the memorandum of the compromise. Then it will pass a decree of compromise decree on consent, provided every party must be present. It is the mandatory section. Now let's see the compromise decree on contest, which is appealable. Suppose A is the plaintiff, there is a suit pending against B, the defendant. The plaintiff and the defendant A and B made an agreement out of the court or entered into a compromise. In court, B says that there was no such compromise or an agreement. There was a dispute between the element of such compromise. Then the court will record such element of compromise. Then it will be contested and a decree can be passed on of compromise decree on contest. So this decree is appealable. Order 43 Rule 1A Sub Rule 2. It was came into force in the 1976 amendment. It says an appeal against a decree passed after recording or refusing to record a compromise. That means contest. The decree could be challenged by the appellant that the compromise should or should not have been recorded, and this decree can be appealed. Section 96 clause 3 shall not bar such appeal. Also, such decree or the compromise decree on contest could be challenged by filing a suit on ground that it was on fraud or undue influence or coercion. Another point, an order recording or refusing to record a compromise is a case decided as per section 115 CPC. So there is a revision lying on this. Now let's see another point. Who may challenge the compromise? Firstly, a party to a compromise may challenge on the ground that there is no compromise or it is not in writing or it was not signed. Suppose the compromise decree was on contest and the agreed party files or challenges the compromise that it was not compromised at all, or there is some dispute regarding it and it was also not signed or writing. So that party can challenge the compromise. Secondly, in the Triloginath Singh versus Anirudh Singh case, the court held that the purpose is to put an end to the various disputes among the parties for once and all. A party aggrieved can challenge the compromise on the ground that it was not in writing or there is no compromise of such. But a stranger cannot question such compromise decree. This is the leading case. Now let's see some more points. No next friend or guardian of a minor shall enter into an agreement or compromise for the behalf of minor without the leave of the court, but they can enter with the leave of the court and such leave must have been recorded. Secondly, a pleader can compromise on behalf of the party because they are on the same footing. Thirdly, compromise decree cannot operate as res judicata as it is not a case decided. However, it will operate as estoppel. Next point, consent decree executable in the same manner as an ordinary decree, but any unlawful compromise or any decree passed by the court having no jurisdiction is a nullity and it cannot be executed. Last point, it does not matter whether the subject matter of the agreement, compromise or satisfaction is identical with the subject matter of the suit or not. Only what is required that it must be lawful. No identical of the subject matter is required. So this is all about Order 23 Rule 3, 3A, 3B of the CPC that deals with compromise decree. Hope you all like the video.